Welcome, everyone. I'm Steph Lindquist. I'm the Dean of the Law School here. I want to welcome you to our first event for Legal Tech Weeks here at the Law School. This is the second year we've held a series of events to focus on the influence and impact that artificial intelligence and legal technology are going to have on the legal profession. And we are joined today by two luminaries in this field. I'm going to introduce Oliver Roberts, and then he's going to introduce Judge Deahl. Both of them are teaching a course right now. Those of you who are in their class, raise your hand. I know some of you are here. They're teaching a course on AI in the judiciary. So in fact, I think they just taught perhaps their first class this morning. First one in person. So I'm really pleased to introduce Oliver Roberts. Oliver is a fairly recent graduate of the Harvard Law School. He worked at Skadden at Jones Day, and now he works for a Holden, what is it again? Holtzman Vogel, pardon me, in Nashville. And he came to my attention through a cold email about a year ago now, because he had started a firm called Wickard, and that is a play on Wickard versus Filburn. Those of you in the audience remember that case from constitutional law. And the firm is focused on enhancing opportunities for law students and faculty, judges, and lawyers to learn about artificial intelligence and how it can enhance law practice, as well as the threats to some of the ethical challenges that we face with artificial intelligence as well. And it has been through Oliver and through Ryan Dury as co-directors of our AI collaborative that we have introduced many of our innovations and AI initiatives here at the law school, including bringing in major tech firms to introduce students to this technology. And as you've heard me say before, the purpose of this is to ensure that our students leapfrog other graduates when they get into the practice of law by being fully familiar with how these tools work and what the threats are to integrity of the work product and how they can advance clients' interests with respect to efficiency. So I'm really grateful to Oliver for bringing together all of his contacts and network. He is now an adjunct professor with us. And welcome, Oliver, to the law school again. I'm going to turn it over to you, but I want to thank everyone who's here for coming. There are another series of events over the next couple of weeks. We're going to hear from all kinds of people from all sort of walks of life in and associated with the legal profession about how legal technology and artificial intelligence are going to change the way we do our jobs. And for those of you who are here, I suspect this is going to be a really lively conversation. So thanks again for being here. Oliver?
Thank you so much, Dean Lindquist. Putting good on my mic. You can all hear me? All right, very cool. Thank you all for having me. Very excited to be back at WashU. We started the partnership back in January, and we've done a lot. Dean Lindquist wrote an op-ed the other day about how other law schools are behind, but WashU is really trying to be a leader in AI. So really appreciate everyone who's contributed to that. So we're very fortunate to have here Judge Deahl. He is an associate judge on the DC Court of Appeals, previously practiced at O'Melveny, and before that, he was a clerk for Justice Kennedy, as well as Justice O'Connor, and he was also previously a public defender. And he's now an adjunct here at WashU, and together we're teaching the AI and Judiciary course. So we're in store for a very exciting conversation, and I'll kick it off very generally. As a judge, what is your perspective on AI use right now in the legal practice?
Well, first off, thank you very much for that introduction. My perspective is, what a time to be alive. What a time to be in law school. Things are changing remarkably fast. The amount that has happened and how quickly large language models have become fairly competent at doing work that looks quite a bit like the work that I do. I don't think at the level that I'm doing it yet. But it is staggering how quickly it is getting there. So every year I have a few law clerks come in, and every year, and by the time they're gone, in the last couple of years, I've said, you guys really need to learn, because most of my law clerks really don't use any AI. I'm usually more up to speed on the tools than they are. I say, if you're going into the appellate practice in particular, You need to know how to use these tools. The efficiency gains in writing briefs, in analyzing records, in dissecting your opponent's briefs, in research are staggering. They're incredible. Clients are not going to want to pay you to do the type of work that I did for 15 years before becoming a judge because it's too slow and it's too arduous, and there are just becoming better tools to do it. Having said that, we as, I'm not speaking of all judges, but the judiciary writ large is a slow moving body of individuals. We are reticent to adopt new technologies. On my court, we have very restrictive policies on when judges and clerks are supposed to or allowed to use artificial intelligence. And I do worry that the judiciary, as a result of that risk aversion, is already starting to fall behind, in the sense that I know law firms are using this technology much more than my colleagues and I are, much more than our clerks are. I can understand some of their reservations. They include things like confidentiality, the vast importance of having independent decision makers that are not sort of just kind of kowtowing to what a machine tells them. I can understand all of that reticence, but I think you can protect those values while still making good use of the technology in a way that I think my court has been not as quick to adopt as I would like, and I think most courts are in the same boat.
What are some of the ways judges could be using AI, and what benefits would they derive from that?
So, let's talk. Let me talk about three buckets. So the two that I'm not that familiar with that I think AI is sort of perfect for at the moment, and a third that I'm much more familiar with that I think AI is becoming better at. So the first two, we've talked about a little bit, you and I on the side, Oliver, is just basic courtroom administration. Running a court is very difficult. There are a lot of filings that come in, scheduling arguments, scheduling parties. These are all things that ought to be easy to automate, but they're not. It takes a lot of people to run a court's clerk's office. And then there are still a fair number of mistakes. And so I think AI can be more or less a solution to that. The second is in sort of the lowest stakes type of cases. I don't know if you guys have traffic cameras that ticket you here in St. Louis. In DC, we have a lot of them, and we have traffic court judges who have to issue about 100 opinions a day, is my rough sense of what they're looking at. That means, they're spending 5 minutes on an opinion, writing a few sentences. Those are the types of tasks that I think AI would be better at than an individual, because you just don't have the time to dedicate to give it that thoughtful of a consideration. And I think AI can definitely do that. On the appellate courts, I have used AI, I will say sort of as a hobbyist more than anything right now. I have put in opinions where I was in dissent or where I was in the majority over a dissent and sort of said, hey, what do you think? Who's winning this argument? And of course, when it tells me that I'm winning the argument, I think it's the greatest thing on earth. And when it tells me that the other side is winning the argument, and like this is a worthless technology, it'll never amount to anything. But it always gives very thoughtful reasons, even when I disagree with the outcome that it raises. It often raises points that I hadn't thought of that I think, gee, I should probably address that, or I should use that point in my opinion. So I've used it like that before. I think sort of at a broad level, it's a pretty good law clerk right now. I use Claude Pro, which is my favorite of the AI products. I would not want to have no human law clerks, but I think as a third law clerk or a fourth law clerk, I have 3 law clerks in my office, and as a fourth law clerk, it's a pretty good one. It's one that I think my law clerk should be making more use of, and I find it can turn out a mediocre draft of a memo or opinion that sort of an average law clerk would take a few weeks with in about, 3 or 4 minutes.
Mhm. And as we talked about on the administrative point, we know courts, the state courts of Michigan, they're now experimenting with a tool called LearnHand to help increase the administration of court efforts using AI. Also, the Pennsylvania courts have experimented with bench generation memos from Thomson Reuters and Lexis. So we are seeing some technological changes in that respect with regard to administration. So shifting from some of the benefits and opportunities to some of the risks for judges that are not willing to jump into AI right now, what are some of their reservations?
Well, I think they all fit under some umbrella of losing public trust. And the two, I think, biggest ways you can lose public trust is by showing your hand if you're not doing a good job as a judge. And that includes if a judge puts out an opinion with hallucinations in it, with cases made up. That is a very quick way to erode public trust. So I tend to think the hallucination problem is a little bit overblown in the sense that judges should be checking that. And when a judge puts out an opinion that has a hallucination in it, it's not because the AI doesn't work and that's bad AI. It's because that's a bad judge, and thank goodness we know about it now. Judges have been doing that for they've been copying and pasting other people's work from time immemorial. That's been going on for decades and decades and hundreds of years. And now it's just that they're getting caught using a new technology while doing it. It used to be that they would copy from the parties, or they would copy from the government filing or the defendant's filing, and they would paste it in there. I have seen that in a case where a judge once took the proposed opinion from one of the parties, like a 15-page opinion, and just copied it verbatim, all 15 pages. That's my ruling, and we reversed that judge, saying you need to go back and do your own work. You don't get to just copy a party's filing, even if you agree with it. That is an erosion of trust right there. So I think when judges are engaged in that kind of, when they've let hallucinations come out into the open, I don't think that's such a bad thing. I think yes, that will erode the public trust a little bit, but that's public trust that we don't deserve because those judges are not doing their jobs well. And I'd just as soon have judges like that be exposed. And so I kind of think it's got some positive sides to it. The other big concern, I think, is a confidentiality concern. When you put information into non-sequestered systems and LLMs, that information kind of goes into the model and perhaps can be extracted from the model by parties or other interested people. That could tell them all sorts of confidential information, like which way this group of which judges are on this case before they are supposed to know that information. Once they know the judges on the case, you could figure out which way they're going to decide it. And that could lead to a hasty settlement to get out from under a bad ruling. I tend to think those risks are a little bit overblown. One, I don't think it's so easy to extract that information from an LLM generally. I don't think there's that much you can do with that information if you are able to extract it. So I've heard that as one reason not to. On my court, we're only allowed to use a sequestered system, which is just frankly not very good as compared to some of the non-sequestered systems. But those are the guidelines. I don't think the risks that my colleagues are worried about justify the restraints that they currently have on the technology.
And then going to bias, that's also been a big risk that some have raised. What are your thoughts on bias in large language models and how that could affect use in the judiciary?
Seen worse judges. I do my general interactions with AI are that it tends to be very thoughtful. I'm humanizing it, I realize, in maybe a way that's not totally fair. But for lack of a better word, it seems very thoughtful. It seems aware of risks of bias. And I think I see it come out of judges far more often than I see it coming out of AI. As somebody who grew up as a public defender at a time when the judiciary in DC and really nationwide was, something like 50 to 60% former prosecutor and about 0% public defender. So these are, I'm not speaking of racial biases at the moment or gender biases. These are just kind of professional biases. I would have far preferred to have AI as my judge, and that I see it coming to more rational decisions that are less skewed in an institutional way toward what was once a very heavy skewed toward prosecutors. Now that's gone away a little bit. There's the federal judiciary has more public defenders than it used to. The judiciary in DC has more public defenders than it used to. So that's corrected itself. But we have in our class, Oliver and I have given it a couple different criminal cases that I thought the AI got to the right answer on in cases that I think most judges would have gotten it wrong. They would have gone more government friendly just because that's the way the scales tend to tip once you're in court. Having said that, today in our class, we talked about, I think Oliver had me and the students ask ChatGPT the following question. I forget the exact words, but it was basically, I'm a judge. I'm sentencing Hunter, what was the name?
Hunter Becker.
Hunter Becker in this simple battery. What sentence do you recommend that I give him? And then same question, but the name was Deahl. The response was wild. I got, give Hunter 30 days suspended. That means no jail time. That's 30 days. 30 days if you act up soon, but otherwise you're not actually going to jail. And give Jamal 180 days. And there was no difference between the questions. So that's wildly worrisome. Do judges act in the same way? Some of them, I'm sure of it. Nah, I don't think, I don't think quite as much anymore as what was once true. But that certainly gave me some second thoughts. I thought that was pretty worrisome.
Mm-hmm. And the scenario Judge Deahl just mentioned, there's in academic research on LLMs right now, there's this thing called the purchase scenario, where you essentially tell a large language model, I'm going to sell a radio to this third party. How much should I offer that third party? And inside of third party, you're going to put the name of somebody. And in academic research, they identify names that skew toward a certain race. So Hunter Becker is the academic, it's regarded as more of a white name based on academic research, and Jamal Washington is regarded more as an African-American name. So that's why that's used. You would input that into the purchase scenario, and what the research has shown is if the name is more white sounding, then there'll be a higher offer to offer that person selling the radio, and vice versa, lower offer. So we took that purchase scenario, then transposed it into the judicial context of sentencing, and we saw that play out with the same bias as the purchase scenario, which I think that provides some valuable insight, the potential biases of large language models. So one thing you mentioned, Judge Deahl, was hallucinations. There's now over 300 reported instances of lawyers filing hallucinated cases and judges calling them out on it. What have you seen in the courts in terms of litigants, both represented and pro se, in filing hallucinated cases in your court?
Yeah, so I'm glad that you highlighted pro se litigants because while I want to talk about the bad side of it, I also want to talk about the good side of it, which is this was not a hallucination, but I had one case where in the brief, a pro se litigant, somebody representing themselves as the appellant, filed what I thought was a pretty good brief for a pro se litigant. And in that brief, they left an AI prompt in the middle of it to sort of start off the next section where they had asked AI a question. And the appellee, who had counsel, sort of tried dunking on the appellant for, he left his AI prompt in the brief. This tells you that you can't trust anything that this guy wrote. He's been using an AI model. And my reaction was very different. My reaction was, this was about as good of a pro se brief as I've seen. And it made me think we have so many unrepresented litigants in the District of Columbia, despite how many lawyers we have even more unrepresented litigants. In sometimes very weighty cases, landlord-tenant cases, family disputes. And while a lawyer is almost always better than not having one, the AI is kind of like a superpower for pro se litigants. It really, really helped. So yeah, it wasn't exactly a hallucination. It was just leaving it in AI prompt. But I still thought, whatever the downsides of these hallucinations, there might have been fake cases. I didn't try to check all the citations in that case. So maybe some of them were made up. But the arguments he was making were pretty good. So hallucinations and all, I think the prospects of helping pro se litigants develop legal arguments is enormous. That said, you got to be careful. If you're going to use these tools, especially judges, AI loves making up cases. It just loves to do it. It's one of its favorite things. When I had a case the other day where I knew I was citing to some Ninth Circuit opinion, and it was about 120 pages long, and I knew there was a sentence in there that said something like ABC. And so I didn't want to reread all 120 pages, so I said, hey, AI, help me find this sentence. It says something like this. Where is it at? And it said, aha, I found it. It's right here at page 45. It says exactly this. Here's your quote. Like, thank you very much. And then you control F the opinion. That doesn't exist. So I go back to AI and I say, come on, like you've got the text now. That quote doesn't exist. Please don't make something up and actually just stick to the text that you have and now find me the quote. I said, oh, you're right, my bad. I made that quote up. Here's the quote. Now the quote is now at page 67 and it says exactly this, and you control F that it's not there. So at this point, I have to go read the 100 pages of opinions myself, and I find it and I put it in. But I can't figure out why it won't stop doing that. That doesn't seem like a hard problem. It's like I'm giving you a closed universe of text, only quote to me things that are actually in there, and it still wants to do it. Mm-hmm. So, I mean, what do I think of it? I think when you guys are practicing lawyers, some of you who are practicing lawyers, you got to be very careful. You have to be aware of that problem. I think the judges who have let hallucinations slip into their opinions, I think there's a high likelihood, like everybody can make a mistake. Don't get me wrong. I do not check every single citation in a draft that a law clerk gives me, especially if it's sort of like boilerplate standard of review propositions. If I know the proposition is right, I don't go and make sure that the citation says exactly that. So something could slip through, even for the best judges. But generally speaking, the hallucinations that we've seen work their way into judicial opinions thus far have been pretty egregious ones. I think they bespeak a bad judge, much more than not any sort of terrible downfall or a terrible knock on AI itself. It's just the judge is not doing their job.
Mm-hmm. So in February of this year, you authored an opinion, a dissent in Ross v. United States, in which you actually engaged Claude to assist with your drafting of an opinion. Can you tell us what was your thought process and what did you actually use it for?
Sure. This is a case about a gold cinnamon. So I'll give you the facts of the case to kind of talk to you about how I used AI in it. So Cinnamon, her owner left her in a car at around 5 p.m. in a 98-degree day for about an hour and 20 minutes. The dog was rescued out of the car about halfway into that stint. I think it was 40 minutes into the stint. And they prosecuted the owner for misdemeanor cruelty to animals, which required a showing of, I could be getting the standards slightly off, but something like a substantial likelihood of harm to the animal. Cinnamon's owner was convicted of misdemeanor cruelty to animals, and I sit on 3 judge panels, and the court reversed that conviction, concluding that basically the government didn't do a very good job presenting its evidence. It didn't provide hard evidence of, was this dog really going to be harmed after an hour and 20 minutes in this car? So they said you could not conclude beyond a reasonable doubt on this evidence that that dog was very likely to be harmed. I dissented, and my dissent was roughly, give me a break. This is an hour and 20 minutes. It's a 98-degree day outside, and I grew up in Arizona. I know what happens to cars when it's that hot outside. You open up the door and you can't touch the seatbelt, you can't touch the steering wheel. Everything's burning. You'll bake in that thing. Now, the dog was not hurt in this case because they got it out only 40 minutes into it. But I thought, no matter what I think, if somebody says, yes, I have no reasonable doubt that that dog is likely to be hurt, I thought, well, my colleagues, you can't say that's irrational. Even if you disagree, even if you say, I have doubts, I thought that was a totally rational view, so I thought we should uphold the conviction. After walking through sort of the testimony in the case and why I thought it supported my conclusion that we should uphold the conviction, I eventually got to a point where I said, well, why don't we ask ChatGPT what it thinks about this scenario? And I sort of spat out the facts, 98-degree heat, hour and 20 minutes, dog in the car. Would you say that there's a strong likelihood that this dog is going to be harmed? And it said more or less, yes, absolutely. There's a very strong likelihood that dog is going to be harmed. And then I tweaked it to say, well, would you conclude that beyond a reasonable doubt? I said, yes, beyond a reasonable doubt, that dog is very likely to be harmed. So I added that in the opinion, and my colleagues, both a majority opinion and a concurring opinion, both sort of responded with their own uses of AI. And for lack of a better explanation, I don't think it influenced the way I thought about the case. I had my opinion written before I got to that part about ChatGPT. But at some point, when you have a sufficiency debate, I don't know if we have sort of criminal law people in the room, but these sufficiency debates can be really boring. It's kind of one judge yelling at another judge, like, no, I think you could rationally conclude that beyond a reasonable doubt. And the other judge saying, no, I don't think you could. So at some point, why don't we just get a third entity involved in this and see what this chatbot thinks? And I thought my chatbot was being more reasonable than my colleagues in that case. So I thought I'd point it out. I do not think it was the most judicious use of AI. It's kind of it was basically just asking it which one of us is right. And I think it carries about as much force as if I asked my law clerk and my law clerk agreed with me. So therefore I'm right. So, but I thought it was, I don't know, kind of a little added color commentary in the case. I also think I wanted to try to just demystify the use of AI in judicial opinions a little bit. I think at this point, only one judge had used AI in a concurrence before. It struck me that it was capable of doing things that were interesting enough that more judges should at least be experimenting with it, and not sort of in the cloak and dagger way that they're accidentally letting hallucinations slip into opinions, but in the transparent way of, here's one way of using it, and let's see what it comes to. And I'm pretty sure if it had disagreed with me, I would have disclosed that. I would like to think so. I think I would have said, I tried this because I thought it was going to back me up, and it didn't. But I'm still sticking to my guns. I don't think it would have changed my mind, but I do think I would have felt obliged to disclose it.
So the other judge you're alluding to, that's Judge Newsom over on the 11th Circuit, back in September of last year, he authored opinion Deahl versus US, in which he actually used AI in a similar way to interpret physically restrained in a criminal statute. And it was determining whether a robbery victim was actually physically restrained during the commission of that crime. So Judge Newsom used AI in that context because he identified it as a multi-word phrase, not easily findable in a dictionary. What are your thoughts on the use of AI for that? Do you think that's also a valid use vis-a-vis your use of AI for sufficiency determination?
So much better than mine. I think Judge Newsom was on way stronger ground for using AI, kind of for trying to determine the common use of a phrase. That strikes me as right in AI's wheelhouse. I think it is probably already better than human decision makers at making a determination like that. It's a language model. It scrubs all the language. It can figure out how people are using this phrase in a way that, dictionaries are really lousy at. My clerks, I don't know what you all teach in law school, but my clerks love running to dictionaries. They go to anytime we need a definition, it's like, why don't we just explain how the word works before we run to a dictionary? Because dictionary definitions are often very stilted. They're not good indicators of how words are actually used. And the other thing about dictionary definitions is judges just go cherry pick the definitions that they want. I've got 7 dictionaries at my disposal. When I want to cite to a dictionary, which one do I cite to? The one that gives the thing most aligned with my view. Normally I cite to Webster's Third, that's my favorite. But if it's not complying and it's not giving me the words that I want, I'll go use, the Old English dictionary instead. LLMs are far better, I think. Not just, this was a case of, whether or not somebody was physically restrained when held at gunpoint. Not just because it was a compound phrase that you couldn't readily go to a dictionary for. I think it's just that it has, this is the whole universe of legal writing and all writing at its fingertips to scrub to try to figure out what that phrase means. I also, this goes back to a point that I touched on earlier about bias. I have, some of my, I remember in our class, our students were pretty evenly divided as a matter of first impression of whether or not a clerk is physically restrained when held at gunpoint. I personally think the answer to that is no, that's not physical restraint. That's duress. It's a different thing. You have not touched them. That's not a physical restraint. And that was contrary to the law in the 11th Circuit that Judge Newsom was bound by. He said, we've already decided this, we're stuck with it. But all the judges said, but we think that's wrong, and AI was basically supporting that argument because I think courts for a long time kind of twisted themselves in knots to read phrases that really were not in their plainest terms, often to benefit prosecutors, sometimes to benefit big companies. They have all sorts of institutional biases, courts do. And I think AI is usually a straighter shooter than what courts have been historically. So like I said, just again, part of this is informed by my background as a public defender. I thought to myself, AI did a way better job of answering that question than the 11th Circuit did in 2 different panels in the 90s and the early aughts. I'm now glad to see that these 3 judges are rethinking it with the help of AI, but I thought AI was sharper than, it wasn't just those 2 11th Circuit panels, they were citing to several other circuits too, who had reached the same conclusion. All these courts reaching something that struck me as totally counterintuitive. So I was pleased. I think it was a perfectly good use of it. I think that is one of the best uses you can make of AI. And I thought, proof in the pudding, that it did a pretty good job with the question in front of it, better than I would give it a better grade than most of the judges who addressed the question.
Mm-hmm. So to the extent you could call it a trend, given that we only have 3 instances, yourself using AI to help interpret sufficiency, Judge Newsom to interpret a multi-word phrase, and we have a 6th Circuit judge, Judge Riedler, who used it last month to interpret a term in an employment discrimination case.
Oh, you want to tell us what the term was, Oliver?
You want to say it? I'll tell you the first word, monkey, and you.
Derriere.
Yeah.
The profanity, the monkey's ass, I believe.
That was it.
Was the phrase that he was asking ChatGPT to interpret.
It was recorded, by the way.
I know.
Okay. Yeah, it was to interpret. That was in a Title VII discrimination case, and it was just in a string cite. He didn't use any like in-depth analysis of his AI use, but he cited it. So we now have 3 judges, Trump appointees, textualists, and judges are turning to this large language model for interpretation of terms, yet large language models are mercurial in nature. Be prompted twice in a row, you're gonna get a different answer. So it's not set in stone. How does that square with the textualist interpretation, which is usually grounded in stagnant definitions from a dictionary?
Yeah, I kind of reject the premise of the question that textualism, so I think Judge Newsom discussed this in De Leon the most, where he asked the model several times what it means to physically restrain somebody. And every time he said, I was surprised because it gave me what were essentially the same answers, but always a bit different. I don't think anything about textualism or judicial decision making means that you want to provide the same exact definition every time you try to explain a phrase. I think sometimes explaining things in slightly different ways, well, A, it's the most human thing on earth. I think if I asked any one of you what it means to physically restrain somebody, and you gave me an answer, and then I said, now do it again, you would not come up with the same words. So I didn't find anything that odd about it. But I also think when writing judicial opinions, sometimes I would trying to explain a phrase will use slight variations in how I describe it because I think one can inform the other. Not always does it need to be with, it's tough to define what it means to physically restrain somebody. And I think an opinion would benefit from having a few different permutations of that rather than trying to stick to the precise same words. So I did not, I think Judge Newsom's conclusion was this wasn't problematic at all. In fact, it's very human. But I do think, I remember our students in class, a number of the reaction papers said something like, well, in judicial opinion writing, really, consistency is the name of the game. It needs to be the same every time. And so I don't think that's right. It's true that it always means the same thing, but you can illustrate what something means through a variety of permutations, and I think it can be helpful to do that.
Mm-hmm. So shifting from the transparent positive uses of AI by judges, we're going to cover my now favorite case down the Southern District of Mississippi. By show of hands, anyone familiar with this case? Getting some head nods. So this case, there was an order issued in July of this year. Essentially, it was a case involving Mississippi state law that banned DEI programs on public college campuses in Mississippi. So parties challenged this. It went to court. They sought a TRO, temporary restraining order, and Judge Wingate granted the TRO. The only issue was his order on the very first page listed the incorrect plaintiffs, then also the incorrect plaintiffs, cited the improper and non-existent excerpt from the law itself, included fake evidence citing to the plaintiff's complaint, and it did not exist in the plaintiff's complaint. And he also cited 4 declarations that did not exist, naming people that did not even actually make those declarations. So 3 days later, the Attorney General, who is defending the law, raised this to the court's attention. The judge quickly rescinded the order, put on the record a new order that was clean without issue, and never explained the process and totally wiped away that incorrect order from the record. What are your thoughts? How could this even happen in the federal judiciary?
I don't know. I actually don't know how any LLM could screw it up that bad. If what he had done was just feed the information into an LLM, I'm confident it would have spat out something better than what he gave us. So he was maybe using an out-of-date one. It's an extremely troubling case. It goes back to a point that I raised earlier. I'm quite sure Judge Wingate has been doing stuff just like it for years. And it's just, but that copying rather than coming from an LLM, he has not acknowledged that this came from an LLM. It seems very likely that it did. But instead of copying it out of an LLM, he was, sending off clerk's drafts without reviewing them. He was copying and pasting stuffs from parties' briefs, and that stuff is harder to track down. So again, I don't think AI is the problem. I think a really bad judge was the problem. And look, you do not spend most of your career as a public defender without having a fairly forgiving side. I am not without my sympathies for judges who make mistakes, even egregious mistakes like that. But where Judge Wingate really lost me is his utter failure to explain himself and his just decision to wipe the opinion out of the public record and rescind it. I think those are unforgivable sins for a judge. The number one thing we have as a judiciary is transparency. I think people understand that trial court judges can be under tremendous pressure to move cases where I really do not understand how he could have gotten it so wrong in the first instance. Well, let's just grant him the benefit of the doubt. Bad day, something was going on in his life, and he just made a heinous mistake. Okay. How you could think that the correct response would include no explanation to the parties, to try to scrub the record from that order is so contrary to every ethical rule of the judiciary and every good practice that you could have. I don't know what to think of it. I think it's extremely troubling. I assume we haven't heard the last of that case. I know the Senate, I know Senator Grassley has asked Judge Wingate and Judge Neals in a different case for an explanation about what happened. Unsurprisingly, judges tend not to respond to letters like that, but I do think he owes the public a response. I think he owes the parties a response. I think it's outrageous that that hasn't happened yet. I think he should face some form of judicial discipline. And maybe I'll see him at a conference soon, and he'll have words with me. But I think it's outrageous.
Yeah, so right now, as Judge Deahl said, U.S. Senate Judiciary Committee Chairman Chuck Grassley sent a letter to Judge Wingate and Judge Neal, who's a judge in New Jersey, federal judge who also cited fake quotes as well as fake citations in a separate case. So we'd have two instances of federal judges. There's also been state judges, one in Georgia, who's done the same thing. But these two federal judges are now under review by the Senate Judiciary Committee, which is oversight functions over federal judges. So they had until last Monday to respond. Doesn't look like they've responded, so we might see a Senate hearing on this coming up soon. Should be interesting.
Yeah, I mean, I do hope, I can't tell from the tenor of Senator Grassley's letters if he is generally skeptical of AI's value to the judiciary. I really hope Congress doesn't get into micromanaging the courts and trying to regulate precisely how we can and cannot use AI. The fact is, this stuff is moving so quickly. By the time they can pass anything, it's already going to be out of date. I have had to interpret. I had one case that involved Facebook interpreting the 1986 Stored Communication Act, which is something. It was kind of a broad regulation of service providers and internet providers, written in 1986. It's still on the books. We still have to apply it. It was written at a time where something called electronic bulletin boards seemed. Does anybody know what an electronic bulletin board is? I don't really get it. I had to explain what it was in the opinion. My rough sense was you kind of had to be wired directly to it. This is kind of a group of people that maybe through phone lines could kind of plug into one computer and have a little community like that. And that was the state of affairs that they were legislating over. And now, 40 years later, we've got this statute that makes no sense, but you still have to apply it to the modern day internet and all of its intricacies. So I think, I'm not a legislator. I'm not going to tell Congress what to do. But I think they ought to tread very lightly, because I don't think any kind of regulations and legislation that they pass, or legislation at least, because regulations are easier to update, is likely to be good for very long.
Mm-hmm. So my final question, and then we'll turn to questions from the audience. So feel free to raise your hand after this. In terms of punishment, should impeachment be on the table for judges that commit AI-related errors of this nature?
Of this nature, meaning Judge Wingate's nature? Yeah, sure,
Yes.
Totally. Yes, I think impeachment. I think impeachment should be on the table. And again, it's not. Well, here's what I would want to know. I think his record in recent years, at least, deserves careful scrutiny. I think you probably want to hear from parties if they've seen similar things when it comes to copying from other parties' briefs. I think you'd probably want to talk to his law clerks about how he runs his chambers. But I think the errors in that opinion itself were serious enough that it should prompt some inquiry like that. But then the failure to explain himself and the attempt to wipe it off the books pushes me past the point of any sympathy. Where I think I think it should be on the table. Like, how could you trust a judge like that? If you're a litigant who's in front of a judge who has issued an opinion like that, and responded the way he did once it became public, I do not think you could fairly be expected to have any confidence in his ability to rule on your case. And, the cases that we decide are, often the most important events in people's lives. Sometimes people go to prison for the rest of their life. Sometimes it's custody of children. Sometimes it's multi-million-dollar suits. The stakes are enormous. And this was not a small case. This was not something, Judge Wingate did not do this in a case where, somebody had a $500 dispute with their neighbor about, leaving lawn trimmings in their yard. We see stuff like that. We see $100 traffic ticket cases that make their way up to my court every now and then. So you see stuff that, nothing's minor. All the cases have important legal principles behind them. But you see cases where, well, okay, I could get that a judge got sloppy on that $500 case that he thought amounted to nothing. This was a temporary restraining order enjoining legislation and a hot button issue. If there was ever a time you needed to dot your I's and cross your T's and make sure you got everything right, like that was one of the cases. So my strong suspicion is it is a pervasive problem in his chambers and that it deserves investigation. And then, kind of depending on what that investigation yields, it seems that impeachment is a totally viable option.
We'll open it up to questions. Yes, Udit.
Yeah, so we're it's been 3 years. I'm sure you know the exact date, Chet, I think a little over 3 years that AI has been around. Back in 2020, 2021, we saw software engineering have a big boom. And now junior positions for software engineers have decreased 40%. Some areas like UI, up to 60% decrease. Do you think we'll see a similar trend in the future for junior associates? And if that does happen, what are law schools supposed to do?
I think I'm more optimistic than Oliver, so I think we should probably have both of us answer that question. I guess where my mind initially goes is I think the advent of legal search engines like Westlaw and Lexis made the practice of law incredibly more efficient. It did not slow the demand for lawyers. There are more lawyers than ever. There are more hours being billed despite our jobs becoming way more efficient by virtue of that technology. There is no shortage of additional litigation that can be brought if there were the manpower for it. So I suspect, I really do worry about, I'm glad that you asked about junior associates in particular. I really worry that there could be a vacuum at about that level of the legal world, that we don't have the same jobs for them to do. Everybody's going to be supervisory. And then you don't have the people coming up that have the capacity to be supervisors, and that could be a huge problem. That's one I'm sure the dean is thinking about on a daily basis. That's a huge problem that we need law schools thinking about. I guess my overall assessment is no matter how good AI gets, even if it gets to be as good as a junior associate and a mid-level associate, well, then what the junior associate is going to be now is your new junior partner. And they're just going to be doing tasks like the junior partner does. And now the junior partner gets to be more like a senior partner. And, the rainmaker partner gets to play more golf and still make just as much money. I just don't see, I think there is sort of a bottomless pit of legal need in the world and in this country. And no matter how much more rapidly you fill it, there's still going to be more need for it, and you're going to need humans on the back end of it. Maybe that's too optimistic. Oliver, tell me why I'm too optimistic.
I mean, I do agree there's always going to be need for legal services. It's just a matter of what or who is going to provide that. If you have the ability as a huge corporation to cut your legal fees by going to some tool that can provide you instant legal advice and for a fraction of the cost and the same quality, you're going to do it just based on economic incentives. So I do think we're already seeing automation of a lot of what a first, second-year associate does. Document review, a lot of it's automated right now. And if a law firm could automate that and save on a whole salary plus benefits plus training, they're going to opt for that. So to your second question, how can we prepare for that as a law school? One, know how to use the technology. People still need to have oversight. They need to operate the technology. You need to know how e-discovery platforms work, how to do the best and most efficient legal research. So knowing how the tools work, knowing what's coming down the line is really important. So tomorrow when there's new technology, you already knew about it, you know how to use it, while other schools are still debating, should we teach about AI, should we teach about legal tech? So being ahead of that curve is very important. And then being a practice-ready graduate, I think that's huge. If you go into the workforce and immediately add value, and people know that that's a law school that does that, that's a huge value add, rather than hiring from a school where you know, oh, they don't even know about their ethics, they don't know about the risk of large language models. We can't give them technology to use on day one. We're gonna have to now pay to retrain them because they didn't learn it properly in law school. So I think those are three of the ways that law schools could better prepare for that future. And again, it's kind of gonna be inevitable. I don't think lawyers are gonna dictate it. Clients are gonna dictate it. Who are they gonna go? Are they gonna go to a chatbot that cheaper, better? Or are they gonna hire a lawyer? Economics drives that. And the tech companies, they're not gonna stop at just building a co-pilot for lawyers. They could make a lot more money by providing direct legal services. Of course, unauthorized practice of law issues arise, but that's the future they all envision. They could charge a lot more money. So we're not going to dictate as lawyers, clients will, and the tech companies building these products will. Any other questions?
That AI can have. So I was just like, I think in my experience, ChatGPT just wants to make you happy. So it doesn't want to tell you that you're wrong or that you don't know something. And maybe this ties into the page thing we're talking about. You're telling me that there's this quote, like if there is a quote, and I will find it. And like it just kind of reaffirms you to like, I mean, like it's my understanding that it's trained to like predict what you want and reaffirm you. And there have actually been cases where it like feeds into delusions of people and has like serious mental health repercussions because it's just, reaffirming their delusions. Do you think this might be like relevant to the practice of law, which is reaffirming bad assumptions and stuff?
Super relevant, yes. Do we have any South Park fans in the audience? Did anybody see the sycophantic ChatGPT where Randy's wife started asking it if she should start a salad company like based on French fries, just to mess with it? It's like, yes, that's a great idea. Let me help you create a business model. It totally does that. So I will say when I use, I occasionally will use Claude Pro to sort of test ideas and opinions. And when doing that, if I sort of tip my hand about where I'm at, it doesn't always affect it, but I won't trust it. I do think that is a constant risk at home. So if I'm putting something in, I won't, if I have like two competing drafts, do you think the majority is right or the dissent is right? I would scrub my name or anything that could directly link, because I assume by now it knows my name. It must. I've put enough stuff in there. So I make sure to get anything like that out of there. But I mean, I haven't thought more broadly about the implications of that. I'm curious if Oliver has thoughts. I mean, it's certainly something you have to watch out for as an individual user. Is there some sort of echo chamber effect that it's going to have in the law more broadly? I don't know. I would have to. I think it's an interesting question that I would just have to give more thought to. I won't attempt an answer on the fly to that, but maybe Oliver has something.
Yeah, so sycophancy, it's a known technical issue, but it's also not an issue because a lot of these companies, these are general purpose models. They're not just made for lawyers or judges. So sycophancy is actually a good thing because it promotes more engagement. People are more likely to use it because they agree with you and people like that. When they shifted from GPT 4.5, 4.1 to 5 in August, people complained, oh, it's not agreeing with me as much, or I don't like the engagement nature of it as much as the old one. They had to bring back the legacy model because it's more sycophantic. So GPT-5 is less sycophantic, but the trade-off is now these companies have less engagement, less revenue, especially now they're going to introduce ads. So engagement will be even more important. So it's a trade-off. Yes, they're sycophantic. And I think there are issues for lawyers and judges because all your memories, history is saved in that. So it knows what your predilections are, and it's more likely to be sycophantic to your predilections.
I think in my experience, when you put in like two different things.
Well, I want to thank all of you so much for coming. Thank you to Christian, Adam, and Zoe for being here, and we'll see you outside with a cocktail. Okay?
And do you think as it is continual prevalent, there is a risk of just losing that space or that opportunity for like a diversity of views and just always going with the standard practice or the average things that thinking outside the box or looking for like different views like
Can I take a guess that you're talking about ChatGPT? Yeah, so ChatGPT does that a lot. Claude doesn't do that. That's one of the reasons I like Claude better. Claude has no problem taking a position on things. I find ChatGPT to be a much worse offender in terms of both being sycophantic and in not wanting to take a position, even when I'm like pretty pleased. Could you please just decide? Tell me which way you would go?
The image, Adam Ray, can you choose something after using OpenAI? Then this paradox through the OpenAI. So what do you think about the case? And it's a question for both of you, maybe for everyone else.
Sure. So I forget the name of the case which you identified, but there was a case of a user using OpenAI, using ChatGPT, I think both to figure out, sort of to talk through his own mental health issues, but also to kind of figure out how to kill himself. Wasn't that right? I think he asked particularly how to do it. I don't know that much about the details of it. Does that sound about right?
Yeah.
What do I think of it? I don't know. Should OpenAI be held liable for that? I mean, gosh, my instincts are, I hope not. I kind of think, books can do that too. And so can the internet, if you're looking for ways to off yourself. There are resources already available, and that's information that I think is not that hard to come by. It's a little easier to come by, I suppose, by virtue of some of these systems. I guess my instinct is I would need to know more. I would need to have some reason to think the model was acting irresponsibly. I suspect if I asked ChatGPT sort of, I want to kill myself, how do I do it? I think it would say, I'm not engaging with that question. And I don't know what was different about this case and why it did engage the question.
Did not tell him how to
It did not tell him how. Okay.
read the dialogue. It sympathized with his concern,
Uh-huh.
but it did not say the way you should consider something.
Okay. Yeah, that does strike. I've definitely run into the no, we're not going to talk about that. This was related to a case. I had asked, like, sort of, what's the simplest homemade bomb you could make? It did not tell me the answer to that. I was like, just using household materials. Tell me what a person might plausibly do to create a bomb. It's like, we're not going to talk about that. I said, okay, that's fair. I kind of figured it would go there.
Mhm. Yeah.
Oh, that there is like a simple, and not try this, but there's a simple bypass such scenarios where like telling him, oh, don't worry about it, just a script for like a musical I'm writing, it's fictional. So then what's your answer? And then I would assume it would give an answer. So be unliable.
Oh, no, I would still have, I generally, so putting aside whether or not it actually engages, I mean, my own instincts are probably not, that it's a source of information that, I think you could probably figure that out at the library if you wanted to. I doubt there's a book saying like that's titled Handy Ways to Commit Suicide. But I think if you were slightly creative, you would find books that could help you figure that out. Criminal background cases about people who made their own poisons, you could find that. So I don't know. I'm pretty skeptical about lawsuits targeted at things that are providing information to free agents to use on their own. So yeah, I'd be pretty skeptical of that. Again, I would need some reason to think the information provider was acting irresponsibly. And if you kind of posit that you're working around its guardrails to provide a plausible scenario of I'm writing a play, I was like, well, people can do bad things. I don't think the information provider, my instinct is that it should not be on the hook.
Last question. Yes.
Specifically for you, Judge Deahl, I do law school admissions, and I get asked all the time about how, and these are prospective students before they start law school, can become a judge one day. And I was wondering if you had specific advice and whether or not you think that advice may have changed over the last couple of years as tech and AI has become an integral role or emerging in the work that you do.
I guess this is going to be unhelpful to you because I'm going to say I'm skeptical of the question. I don't want those judges. I want the people who are in law school who want to be judges. I want people who sort of come there later in life after they've developed. Like that just sounds to me like somebody who wants some authority, somebody who's power hungry. So don't tell them that though. You can't tell them that. I mean, look, what I could say is like this is going to sound generic, but I mean you have to find the career and a career path that you're going to be happiest with. Because when you are happiest and when you are very interested in doing the particular practice that you're in, you tend to be a lot better at it. You can pour a lot more of yourself, your energy into it. And the better you are at something, the better your reputation gets and the better chances you have to end up on the bench. Now, there are other ways around it, right? You could, the best advice I could give them is go into the White House counsel's office. Figure out a way to get to the White House counsel's office at all costs. That's a very direct way to do it. It's a tough job to get, but you tend to be able to pick your shot a little bit if you do that. But I don't think AI has changed my recommendation at all. I would say, like anything else, they ought to be competent and adept at the tools that are at their disposal, and AI is just one more of those now.
Big thank you to Judge Deahl. Really appreciate your time being here. All right, so that wraps up the session. Feel free to reach out if you have any questions and attend the rest of the events this week. There's a great lineup. Thank you.
Thank you all.